Welcome to the Inventor's Edge podcast, where insight meets innovation. Whether you're sketching your first idea or refining a finished product, you're in the right place. Our mission is to equip you with the tools, expertise, and clarity you need to succeed as an inventor, while helping you conquer fears and limiting beliefs that may be holding you back. I'm your host, Scott Putnam, founder and CEO of Inventor's Edge. Before becoming a seasoned product development coach, I was a wide-eyed inventor with a head full of ideas but no clear path forward. I know firsthand what it's like to feel stuck, uncertain, and overwhelmed. Fast forward to today, I'm a successful entrepreneur with multiple licensing deals and products on the market. I'm committed to helping inventors like you overcome obstacles, conquer fears, and transform your ideas into tangible success through proven, actionable, step-by-step strategies that deliver real results. Join us as we bring in industry pros, share expert advice, and dive deep into the world of innovation. Ready to turn your ideas into reality? Let's get started. Today's guest is a total game changer in the world of intellectual property. Meet David Spears, IP attorney at Burris Law, founder of Spears Enterprises, and host of the must-listen podcast, Everything Intellectual Property. David is not just an attorney, he's a former Division I running back turned engineering brainiac who now protects innovation for a living. With his deep experience in robotics, automotive, smart tech, fitness, and beyond, he knows exactly how to turn big ideas into protected, profitable assets. From negotiating with the USPTO to guiding inventors through the legal maze with clarity and confidence, David is a fierce advocate for creators like you. And today, he's pulling back the curtain on what it really takes to safeguard your invention and build a strategy for long-term success. If you're an inventor, entrepreneur, or just someone with an idea worth protecting, you do not want to miss this episode. Let's jump in with David Spears. Hey, David, welcome to the show. How's it going today?
Going pretty good, Scott. How about yourself?
Doing great. So glad to have you on with us, and I'm excited to share, see if we can tap into your knowledge base and your skill set. Yeah, tell us a little bit about yourself. Where are you from? And anything you want to share is great.
Oh, absolutely. First off, thanks for having me. And I know as someone who has kind of a platform myself, anytime you're bringing someone on, you hope that they add value to kind of your audience, and kind of you just don't want to let anybody on if you don't think that that can be the case. Thanks for believing that I could add value to the audience and allowing me to kind of speak to the audience here today. Kind of going back to the background question, I'm currently in the Detroit metro area, but I'm kind of from the west side of the state of Michigan, small town called Muskegon. Just kind of growing up playing football, like most kids, sports, basketball, things of that sort. And then my kind of background or path into patent law and being an IP attorney is pretty unique. I went to undergrad at Michigan State University, where I not only played football, you see kind of the jersey in the background there, but I also majored in mechanical engineering. And then I guess I liked Michigan State so much, I decided to go to law school there, Michigan State University College of Law, graduated and kind of moved from the west side of the state further and further east. Michigan State is kind of more so central Michigan. And then after graduating law school, I kind of moved to the Detroit metro area, which is on the east side of the state of Michigan. So that's, I guess, a little bit my background in a nutshell in terms of kind of where I was born and then coming up through Michigan State for undergrad in law school and kind of now residing in the Detroit metro area where I, just practice IP law, patents, trademarks, copyrights, those type of things.
That's awesome. Thanks for sharing that. So mechanical engineering and a patent attorney, that's a great combination.
No, for sure. And I would like to say that I drew it up that way, but that wasn't necessarily the case. Just having some good mentors, a cousin of mine who doubled as my mentor that freshman year. Most collegiate athletes, especially at the Division I level, the thought process is, hey, we're going to kind of focus on our respective sport, and then we'll figure out this thing out later. At least with the football players and a basketball players, I would imagine other sports may be a little different. But I guess coming into undergrad, your freshman year as an athlete at that level, you're trying to focus on your sport and then kind of figure out the rest of the stuff later. But I mean, I got a great mentor who told me, hey, you like math and science, do engineering, and then to the extent that you wanted to go to law school, you still want to go to law school, you can do that. So that's kind of where the mentorship came in to play for me, and it kind of paid dividends all these years later.
That's great. Sounds like a great mentor.
For
You know,
sure.
instead of getting some random degree and really focusing on the football, thinking, "Hey, I'm going to go pro, so the degree doesn't matter." Really saying, "Let's make this count, right? Let's get a degree that I can do something with, and then continuing on to law school." That's amazing.
Well, again, just I was pretty green back then, so thankfully I stayed with him and before enrolling at Michigan State, and he stayed in Lansing. Michigan State is in East Lansing, which is pretty much right next door to Lansing.
Hmm.
And again, he was an attorney, but he was a criminal attorney, and he did some personal injury as well. So just kind of coming home, and he's kind of telling me about the different cases he was dealing with. I'm like, oh, this stuff is interesting, and it was a funny story because as you look back on it, the criminal stories are always interesting because the criminals doing something dumb makes for interesting stories. As he was telling me his stories, I'm like, oh, this is cool. I want to go to law school. And he did political science in undergrad down at Jackson State University. So the initial thought was, okay, I'm going to do political science and then I'm going to go to law school. And that's when he told me, hey, you don't want to get a political science degree. No offense to anybody who has a political science degree, but he says, hey, if you decide not to go to law school and you just have a political science degree, you're going to be tough. You're going to be stuck. So he was like, you said you like math and science, do engineering. And if you want to go to law school, you can still do that. And to be honest with you, at that time frame, I wasn't even thinking about patent law. Little did I know anything about patents and anything like that. I just kind of came to learn that as I was kind of going through undergrad, and then things started to fall in place, and I still wanted to go to law school, and then kind of it was like, okay, everything
Hmm.
just kind of started to fall in place and make sense for me.
Yeah. Are you also an inventor, even as a little kid, like coming up with new ideas?
No, and that's a funny story as well. I think being coming up in an environment that I came up in, which was a predominantly urban environment, I would say I was definitely an entrepreneur. Had the paper routes, shoveled snow, uh, and raking leaves and things of that sort. Just kind of having that entrepreneurial mindset and kind of wanting to kind of earn money at that point in time. And I think just kind of also growing up in that environment and maybe not having a ton of money, uh, you have to get creative when you're trying to do things, play outside and things like that. So I was tinkering around, and I always kind of my older brothers kind of bought their maybe kids something for Christmas. I always kind of was putting that stuff together. So I think it was always there, even though I really didn't know the terminology back then. I think it was always there from an entrepreneur, inventor, kind of tinkerer. And it's cool that it kind of played out kind of years later where I was able to kind of not only, just help people out with their inventions and kind of really understand the landscape a lot better.
Yeah, that's awesome, especially as a patent attorney who is a mechanical engineer to also having that inventor mindset. You know what the thought process is for the inventors and your clients that are coming in with their invention that they're so passionate about. So that's
No, for sure. And it also, it's kind of a good thing and a bad thing also with kind of understanding the difficulties of not having a lot of money to start out for a lot of people and just trying to get the most out of what they can. And again, I understand that just kind of from where I came from. So that's a good thing in a sense that you can kind of relate to people on that level, but it's a bad thing from an attorney perspective because it's like, okay, it's we got to make sure this person pays the bill. So it can be a good thing and a bad thing.
for sure. Yeah, well let's jump in. Let's start with the basics here. Some people are much more seasoned in terms of their knowledge base with IP law or patents in general, and some are brand new. What would you say, I guess, why is intellectual property so important for inventors in general? And then what are some of the main types of IP that people should just know about?
Right. No, yeah, I think it's important just because, and I've seen this on a day to day basis. I kind of cover and interview myself a lot of the Shark Tank guests, and as well as kind of help out small inventors myself. And it's, I hate to say it like this, but it's almost like a way out in a sense. If you're maybe kind of come from humble beginnings or humble means, it is a way for you to be able to invent something, create something, because we all have ideas. We are all creative in a sense, whether it's copyrights or whether it's inventing, which is patents, or we're starting a business and we want to provide a service or sell a widget, which is trademarks and kind of branding from a trademark perspective. We all have this ingenuity inside of us And it's important for us to be able to kind of understand how to protect these different things so that we can kind of monetize it the best way possible and also keep others from kind of taking our stuff. So I think that's why it's so important to be able to kind of protect your intellectual property because, again, it gives you a way to be able to kind of monetize your product without others and providing a recourse to the extent that others are looking to infringe on your IP in different ways. Then I would probably say the four important forms of IP that everybody should have a baseline understanding of. And we know, I think, three of these are pretty. I think most people know three of these, or a lot of people have heard these three trademarks, which protects branding; copyrights, which again protects creative works, whether it's a book or a TV show or a sound recording, some music, movies, things of that sort, 2D pictures, 3D pictures. And so that's copyrights. And then the third one is patents, which again is if you invented something, that's going to be protectable via a patent. And obviously we can kind of break that down between design patent or utility patent. But then the fourth thing that people don't know about is trade secrets. And I want people to really understand that, just because number one, a trade secret, we're talking about patents, and I don't want to kind of get ahead of myself, Scott, so stop me if I am. But we're going to talk about patents and how you have those time bars. But trade secret is confidential information that gives you an economic advantage in the marketplace. And I think a lot of people should know about that. Particularly, you see it a lot in kind of in a restaurant industry with recipes and kind of food items, food products. Again, to the extent that you are exposing or publicly disclosing kind of that secret sauce, you no longer can get a trade secret on that. So you want to be able to make sure you're taking reasonable measures to protect that confidential information. Whether there's a recipe, think about the Coca-Cola formula, that's kind of protectable via trade secret and allows Coca-Cola to be able to benefit economically as long as they can keep it a secret. So I think a lot of people should really understand trade secrets as well as being that kind of fourth form of intellectual property that's out there that really it doesn't get filed with a governmental body. So when you're talking about copyrights, that's the Copyright Office. Trademarks and patents, you typically file those with the United States Patent and Trademark Office. However, with a trade secret, that's something that you're keeping a secret. So whether you are putting it in a password protected USB drive or you're locking up the secret sauce in a safe, it's something that you're keeping a secret as opposed to filing paperwork with the governmental bodies. Yeah, I think that fourth one is a big one that a lot of people should really understand as well.
Yeah, it's such a good point. I think if somebody had a recipe, not just even for food, but I think of like car wash or car wax, where if you patent that and you put it out to the public, you're putting all your secret sauce in there. You're just giving it to the world, even though you think you're protecting yourself because you file something on it, but you're more protected to just hold on to that recipe, put it in the vault, and just kind of stow it away.
And you bring up a good point with that, because a lot of times a trade secret can be protectable in a lot of instances with a patent. But you have to think, okay, the patent that lasts for 20 years and then that's kind of disclosed to the public, whereas a trade secret, it lasts forever as long as you can keep it a secret. So a lot of times that kind of subject matter, the processes, the formula can potentially be protectable via a patent. But this where it really kind of comes into play with having a good IP attorney, a good patent attorney to say, hey, let's not file a patent on that. Let's keep that as a trade secret. Manufacturing process is a big one. Do you have a process that's going to give you a leg up in competition? If that's the case, and you may want to consider keeping that as a trade secret as opposed to filing a patent on it, where again you have to disclose. That's the biggest difference. Trade secret, you're keeping it confidential, whereas a patent you have to disclose a secret sauce. So they're like opposites of each other, but they kind of overlap in a lot of ways in terms of kind of what can be protected. So you want to make sure you're kind of going about the best way of protecting that particular process or system or whatever the case may be.
Yeah, and it's so helpful to talk to really good guys like you that are going to say, hey, instead of just taking your money and let's just file this thing and then I get paid, saying, you know what, you're actually better off by not filing it. That speaks volumes to your character as a patent attorney.
And not only that, I think it kind of one of my big models is really just providing value and just understanding that kind of God and the universe is going to kind of bring it back to me in some form of fashion over my life. So if you're kind of giving good counsel to people, I think by them going out and talking about, hey, I have a good patent attorney or whatever the case may be, I think that it ultimately comes back around also. But again, goes back to my earlier point. I understand that this stuff can be, it's important, number one, but I know understand that it can be somewhat expensive. So I don't want to, kind of take people for everything that they got. I do want to provide kind of sound, sound advice and kind of hopefully allow that business to flourish and kind of benefit as much as possible as relates, I guess, it monetizing and kind of providing a difference in the world here.
Absolutely. That's so great to hear. It's nice to know there's some really good attorneys out in the world that do care about people.
And it's funny that you said that, Scott. I again just doing these interviews, and I probably interviewed over 100 people at this point in time. A lot of those guests have been on Shark Tank, and
Mhm.
the number one thing I get is, man, I wish I would have found you earlier on because, man, I had to go through the school of hard knocks as it relates to IP and kind of doing a lot of different things wrong. Maybe, and I one of the things I didn't realize because you're kind of in this bubble, so you almost think that I understand that all attorneys are maybe created equally, but you don't realize that some attorneys are better communicating than others, and kind of really makes a difference with regard to the client. So a lot of
Mhm.
stories that and I talked about how maybe their first patent attorney or their second patent attorney was not maybe the greatest for one reason or another, and that's something that I just took for granted, quite frankly, and I didn't realize that you can have maybe an attorney that just maybe didn't want to communicate or didn't communicate or let things kind of fall through the cracks. Yeah, it just kind of made a difference on what was able to be protected.
Mhm.
So yeah, I don't know, just kind of learning from those interviews that there's some attorneys out here that unfortunately make things a lot more difficult for you as the business owner as opposed to easier.
Exactly. And that's for us, with Inventor's Edge and wanting to interview really good people, it's nice to shine the light on you and say, "Hey, here are some really good people that you can work with that really care about you, care about the outcome, want you to be successful, not just, another client to get a paycheck from." That's awesome. Let's talk a bit. You mentioned earlier about some of the time constraints with patents. I know it can be a bit of a race against the clock in a lot of cases. Can you sort of outline what are some key time constraints that inventors just need to be aware of when it comes to, filing for patent protection?
Oh, absolutely. And I would imagine that with your program at Inventor's Edge, that you also talk about these things, but just the filing date. The filing date is going to be important, not only here in the US, because the US is, to be honest with you, they are one of the more better patent offices because they do give you a grace period. So to the extent that you have a public disclosure, which means you're disclosing it, again, you can be disclosing it really to your family, and that can be considered a public disclosure. And therefore you have a year before you have to file that patent application, or else you're forever barred from being able to get a patent on that particular thing. But some countries, uh, you know, they're not as graceful as the U.S. And once you have that public disclosure, you are barred from filing for patent protection in that country. So you just want to, just as a kind of rule of thumb, just file whether it's a provisional patent application, which I'm sure we're going to get off into. You want to make sure that you file something before you start to disclose it, whether it's you're disclosing it to family members, whether you're disclosing it to a presentation for potential client or potential manufacturer or someone that you're working with, a vendor, or you're selling it. You want to make sure that you have something on file that's going to protect it. Now I will say that if you have a confidentiality agreement in place or some type of NDA agreement with that particular person, to the extent that is one person or a company that you're disclosing it to, that doesn't start the clock to tick as far as that grace period or count as a public disclosure. So to the extent that you're just in a hurry to kind of disclose this thing, you can't get something on file for whatever reason, make sure you have some type of NDA or confidentiality agreement in place with that person or company, because that will not count as a public disclosure to the extent that you are able to have that agreement in place before disclosing the invention with someone else.
That's a great point. How about if it's several, let's say you're going to show it to a boardroom full of 50 people, but they all fall under an NDA? Does that
Yep, and that's it. So it's one thing if you're talking to one person and whether that person is representing himself in his individual capacity or his company. I mean, it's just easier the NDA agreement is a lot easier at that point. But as you talked about in your example, once you start kind of showing these things to groups of people, you're just better off filing something beforehand. Because
Hmm.
I think it becomes a little dicey. Okay, does the agreement, again, I guess you can, if you are showing it to 10 people, you can have each one of them sign an NDA agreement, but it's going to be a lot easier just to be able to file something, even a provisional application, as opposed to trying to have 10 or 20 people individually sign some type of a confidentiality agreement. Because that's the way I would kind of go about it. I would never say, okay, this one person is signing it for the group. I would have each person sign that NDA that I'm disclosing it to. And
Hmm.
it seems like that's probably not as ideal as maybe just getting something on file before disclosing it to that group of people.
We always recommend filing a provisional patent to start with. It's cheap, it's relatively quick to do it. It's not a big investment. You have patent pending. And then you don't have to ask everybody that you want to share your idea with to sign an NDA. It's kind of like dating, like, hey, sign this before we go on our first date. It's like, wait, what? What are you talking about?
And that's interesting. I have a buddy, one of my best friends, actually, he was my roommate. We played football together at Michigan State, and he was my roommate in undergrad. And he has this really cool product, and I'm trying to push him to, hey, man, do something with it, do something with it. And I guess he was going to talk to one of his good buddies who maybe was a designer or something along those lines. And I'm like, hey, well, if you're not going to file a patent application beforehand, then you should have him sign a confidentiality agreement. And it seems like that was like nerve wracking to him for whatever reason, to have his ask his friend, because I guess he kind of looked at it as, okay, is he going to think that I don't trust him if I'm asking him to sign an NDA agreement?
Mm.
But it just kind of ways that I think you can go about it of explaining it to people such that they understand that, hey, it's not personal. I'm not doing this because I don't like you or that I don't trust you. I have to do this, or else I'm not going to be able to essentially get a patent and protect my ideal. So it's ways that you can explain it to others in a way that it doesn't come off as, okay, you don't trust a person or you think they're going to steal the ideal. And I would probably say kind of focus on that. Just say, hey, it's not necessarily you that I'm worried about. It's just kind of the USPTO has these rules that I have to kind of make sure that if I have this, if I don't have a disclosure, if I don't have this NDA in place and I'm disclosing a secret sauce to you, then it can prevent me from getting a patent. So that's kind of, one of the reasons why I'm doing it. So it is ways that, at least in my opinion, that you can explain to others, kind of make it such that it's not as awkward, and especially if you're not going to be able to file a patent application. But again, to your point, definitely, if you can get something on file beforehand, that's kind of the way to go. But for one reason or another, it seems like everyone can't always go that route for whatever reason.
Yeah, thanks for explaining that, because that comes up a lot. Like, hey, I want to show this to my friends or a group of friends, but I feel weird about asking them to sign an NDA. I love the way you explained it. Like, hey, this isn't personal. This is something the USPTO requires so that I'm like committing the public disclosure piece, which can invalidate my patent. That's some nice juicy ammo for them to be able to have that conversation and not make it weird.
Right, right, yeah. Because if you just say, "Hey, man, sign this NDA before I, explain this invention I have to you," they're gonna be like, I mean, maybe they don't say it out loud, but in their head they're gonna be like, "Screw you, what you don't trust me," but kind of putting the onus on the USPTO
Yeah.
or on another other party, which it is. It's true. Like, if you don't have this, then this can kind of bar me from getting a patent. Then it seems like hopefully they're a lot more acceptable to that, and that kind of makes more sense. And they're like, okay, I get it, as opposed to it's not being me personally that you don't trust. It's kind of this third party that it can derail things if I don't go about it this way.
Yeah, absolutely. I want to jump here to the inventors that are listening that might be feeling a little overwhelmed with the whole patenting process and what's involved. What would you say would be some of the first steps that the average inventor could take to protect their idea?
Yeah, I would probably talk about, or say, like you said, that provisional application. A lot of times, if you are, if you're starting out, you're probably going to be considered a small entity. And
Mhm.
at that point, it's like $100 or something to file for a provisional application. But I will say, just kind of be careful when filing a provisional application, because that is only as good as the information that's in it. Uh, I was just kind of talking to a client the other day, and yeah, we can, and you can literally draw something on a napkin and file it, but understanding that if you have all these additional details that you're adding that was not shown or disclosed in that earlier provisional application, then they're not going to get that provisional filing date, because all a provisional application is not examined at the USPTO. It's like literally just a filing, gives you your place in line. And
Mhm.
that is only as good as the information that's in it. So make sure, to the extent that you are filing that provisional, and I think that is one of the good things that you can do at the beginning, especially if you're kind of strapped for cash, to file that provisional. You can kind of almost do that yourself. Even though I would kind of recommend at least kind of paying an attorney some money to kind of look it over. You want to make sure that that has as much information in it as possible. To the extent that it's a mechanical case, I will have all these drawings in it as possible, showing different views, maybe cross-sectional view, just so that you can have support when you go to convert that provisional application into a non-provisional later down the line. So as much information that you can put into that provisional as possible, I would strongly recommend that, just because again, that provisional is only as good as the information that's in it. And to the extent that is lacking in information, and then you can still claim priority to it within a year when you go to file the non-provisional. But to the extent that you're adding all this stuff that wasn't included in the provisional, then you're not going to get that filing date of the provisional application for that additional subject matter.
So it sounds like the more the merrier. Take all of your optional design elements, the other embodiments, and the kitchen sink, and like put it all in there.
Exactly. Yep. Throw the kitchen sink in there. Maybe have a description of what's going on, and kind of generally what's going on. And I think that would definitely help out, go a long way, as opposed to maybe just having a stick man on a napkin and then filing it and then disclosing everything to everybody and thinking that this stick figure that you filed on the napkin is going to carry to the day later down the
Right.
line. So yeah, I'll definitely. That's a big thing that I would say. Just make sure you understand what's going into your provisional, and that provisional application is only as good as what's kind of supported in it, if you're trying to claim priority back to it, at least.
Perfect. What about patent searching? Do you recommend people do that on their own or have a professional do that just to make sure the runway is clear? Or how do you advise people on that
Yeah,
part
no,
of it?
and I would probably say it's always going to be easier to do it on your own at the beginning, at least. And then, to be honest with you, Scott, I would probably say somebody coming to me, because attorneys can be hard to get up. Patent attorneys, particularly for small inventors, unless you have a friend. I was interviewing a couple people this past couple weeks, and it was interesting because they were inventors. They were kind of inventors, and they kind of are doing pretty good with regard to their business. But they had roommates who just so happened to, college roommates who so happened to go on to be patent attorneys. So unless you kind of really know somebody who's a patent attorney, it can kind of be difficult if you're a small inventor to get a hold of a patent attorney. But one of the things that will help you out in that regard is if you kind of come to them like, hey, I got this invention, I did some searching, here are some patents that I found. That just kind of could go a long way to say, okay, this person is serious, as opposed to coming to a patent attorney and saying, hey, I need help with a product or invention, and I haven't done anything on my own. That is like, okay, I really want to kind of go through, because really patent attorneys, and I'll kind of give the audience another tip. Typically, patent attorneys, they want like a continuous flow of work. So that's why they kind of go after the big guys, right? Because they know Microsoft, Apple, they're going to give you $1 million, $2 million a year of a book of business. And that's what you want as a patent attorney. It's kind of tougher, unfortunately, to kind of deal with one-off clients, where they're going to maybe give you 7, 8,000, but it's going to be for 1 year. But then you have to kind of hold their hand going through the process with them. That is not as ideal to a patent attorney already. But again, you want to come to them as buttoned up as possible. And I think having that search kind of already done, it can go a long way. And maybe having some references, it can kind of show, scream to your patent attorney that, okay, this person is serious, and this is somebody that I want to work with. But kind of going back to your question on the searching, the good thing is the headquarter United States Patent and Trademark Office is in Alexandria, Virginia. So, to the extent that you're in that area, you can go actually use those search rooms or those computers that the examiners at the USPTO use. Those things are really quick. You can get through a lot of references, and they actually have resources there on site that kind of helps you, kind of learns you, teaches you the ins and outs of searching. They do have 4 think they just opened up a fifth satellite office. The good thing about being in the Metro Detroit is they have a satellite office in Detroit, which actually my law firm is in that same building. You have a satellite office in Colorado. I think Denver. You have a satellite office in Silicon Valley. I think you have a satellite office in Texas. Then they just opened one up on the East Coast. I forget the state of that fifth one, or the state of the fifth one. I want to say it's like New Jersey or New York or something like that. So to the extent that you are near those areas, I would strongly recommend you go use those search rooms, just because you're going to be able to get through a lot more references as compared to you using Google Patents or the USPTO online database. But to the extent that you are not located close to one of those search rooms, do a Google Patent search, do a keyword search, and I think that's going to help out, at least give you an idea of the landscape and kind of what's out there with regard to your invention and kind of what it is that you're trying to get a patent on.
And really, as the inventor, you are the expert in your product idea. So the more research that you can do and the more patents you've looked at the drawings, looked at the claims, really kind of just getting used to that language, I think is such a big piece. And it's great to know that there's satellite offices you can walk in and there's people that can help you do this, it sounds like.
Yep, no, for sure. Yep, at those satellite offices, as well as the main office in Alexandria, there are staff members that's dedicated, because they understand it too. The United States Patent and Trademark Office, that hey, the backbone of kind of what we're doing here is really small businesses, and so we need to kind of put some resources in place to help out those small businesses, or those small inventors, to be able to help them search and kind of get through this patent process, because it can be overwhelming if you're trying to look at it, and you're not even really, the main thing is you're selling your widget, providing your service, and the day-to-day operations of it. But this IP thing is a part in that process, and it's a very important part in my opinion. So to task somebody with, okay, hey, run this business and deal with manufacturing and marketing and all that, but then also know everything about IP, it's like an insurmountable task in a lot of cases. And I think the USPTO understands that and have been trying to provide resources for people who've kind of are trying to start a business and protect their IP. So they do a pretty good job of that.
That's great. Yeah, I've been to the USPTO in Alexandria, Virginia. It's an impressive place. It's just the building itself, and they have that little museum in there. It's such a cool place to visit. So anybody that's listening, if you're near that area, it's definitely worth checking out. Changing channels a little bit, you think about, as inventors, we want to, of course, avoid mistakes along every step of the process. When it comes to patents, what would you say are some of the most common mistakes you see inventors make when you're talking about patents or other forms of IP? And how can people really avoid that? I think that's what we all want to know.
Yeah, no, great question. I think the big mistake that I commonly see, which kind of talked about a little earlier, is just not being understanding the time bars. And again, as much as I say that you can do some of this stuff on your own, it just kind of benefits to have an IP attorney on your team, a patent attorney on your team, just because you're running the operations, you're running the day-to-day operations. Actually, I have a couple interesting stories. So I own kind of the podcast. I kind of talk about current events, and it was this business owner. I think she had a salon or something, and she was overseas. I think she was overseas. I forget the name of the country, but she was doing good, expanding, opening up multiple locations. And in doing that, she forgot to renew her trademark application. And as a result of that, the trademark went abandoned. Then L'Oreal, they ended up, so she refiled the application, but now at that, and she had the trademark again to renew it. It's coming up on 10 years at this point. So to renew it, since she had to refile it, L'Oreal ended up kind of stepping in based on some trademarks that they had filed in the meantime, and they were essentially looking to block her from being able to get the trademark on her, really the mark that she had already trademarked. And I think she's going to get it, but going to have to spend a ton of money, and she already has had to close down shops as she's kind of tried to fight kind of L'Oreal and the trademark office to do this. So I think, again, if she would have had a good attorney on her side to let her know, hey, this renewal is coming up, do you want us to pay it? Or some kind of third party service that helps out with that, she could have avoided that altogether, which is kind of leading me into that to the next story, where it was a Shark Tank product, a business that I had on the podcast, and I was talking to them, and they kind of were talking about how they are killing it, crushing it in the US market, but they're looking to go. I think they were starting to really kind of pick up steam. I think in not Europe, but the UK maybe, somewhere in Europe. But since they weren't protected in that particular country, they, essentially it's free for all at that point. They can't kind of go after people for infringing on their patent in that particular country because they have no patent. And the reason that they weren't able to get a patent because they just kind of missed the time bar. They missed kind of filing for patent protection in that country beforehand. So they're kind of trying to kind of go through these loopholes, find a loophole to be able to kind of protect their invention in that country. But the biggest thing, kind of answering your original question, is just understanding the time bars that are out there. In the US, they're good because they give you a year grace period. But to the extent that you have a product that has a market elsewhere overseas, then you kind of really need to understand what is that country time bars, and a patent attorney is going to be able to help you out with that. So I would say definitely just kind of making sure that you are understanding of the time bars, and to the extent that you are disclosing it, making sure you have that NDA or some type of confidentiality agreement in places. I would say is the two commonly mistakes that I see just from kind of the interviews, as well as kind of dealing with people and just kind of dealing with clients and prospective clients on their invention.
Yeah, I think of mistakes. The time bar, I wouldn't really have thought of that as one of the big mistakes, but that makes complete sense. You're missing these deadlines. All of a sudden, your patent or your trademark goes abandoned, and you get a notification. It's like, wait a minute,
Yep.
what just happened?
For sure. And then I would probably say a third one is just understanding that it's a lot of power. I know we've been talking about provisional patents and utility, but there's actually three types of patents you can get. You can get a utility, you can get a design patent, which protects the ornamental feature of it. Utility protects more so of the function. Then you can get a plant patent as well, which I'm not going to talk about too often just because I have never dealt with them, but that is a thing that you
Yeah.
can get, a plant patent. But the design patents, they can be so powerful or a fraction of the cost of a utility matter. I actually just filed 2 design patents, and for a small entity, I think they're like $500. Now you can't file a provisional design patent. You have to kind of file the real thing from the beginning.
Mhm.
To the extent that you're a small entity, that's $500-$600. The attorney fees maybe only another $500-$600, and your biggest cost may end up being the actual the drawings that you have to have a draftsman do. But
Mhm.
those design patents, they can be extremely valuable. I was watching Shark Tank, one of those. I'm not sure if it was this season or last season, but it was and I forget the name of the actual company, but it was like swimwear that had it was a weird company. Now it was
Mhm.
like I had a cutout in the backside of the swimwear, so you can kind of see your the upper part of your, excuse my language, like the butt crack area. And
Okay.
like I said, it was a weird company, but they knew they weren't going to be able to get a utility patent on it. So, but they were able to obtain a design patent on it. And Kevin O'Leary, Mr. Wonderful on Shark Tank,
Mhm.
because I think it was more so for like maybe again, just they said it on the show, so I'm not kind of saying anything disrespectfully, but I think it was for like maybe gay man.
Mhm.
Uh, and Mr. Wonderful kind of, he was like, man, I can really kind of use this. So he offered him $100,000, not for the business, just for the design patent.
Ooh, wow.
So he didn't care about kind of what they were doing up until that point with the business. The fact that they had this design patent was valuable to him. And he offered them $100,000 to walk away from the company and assign him the design patent. Now they turned that down, but that just goes to show you the power of design patents that
Mm.
people really don't think of and take advantage of, especially if you can get that utility patent. And the ornamental feature of your product is important. That design patent can be a big way that you can really monetize and protect your product.
That's such a great point. You nailed it there, talking about if the ornamental part of the product is important to the function, right? That's huge.
For
I
sure.
think about my Swat and Scoop product, and I filed a utility patent and another utility patent and started with a PPA. But I've had a couple of patent attorneys say, because of the shape of this thing, you should really consider a design patent
Sure.
because it really would protect you.
Absolutely.
Because it would be hard for someone to change the ornamental part of it because they'd have to change the whole shape, which would therefore change the function of it.
Yep. No, absolutely. And man, again, I'm seeing that more and more often these days where that design patent is, man, it's for a fraction of the cost, it can provide just as much protection as a utility matter in a lot of cases.
Thinking about, you mentioned some of the changes and the trends. What's going on right now in terms of changes or trends in patent law that inventors should really have on their radar at the moment here?
Yeah, I think AI is a big one.
Hmm.
Again, you can, unlike maybe copyrights, which it seems like that copyright laws are forever changing as it relates to AI and being able to protect it. You can protect inventions that incorporate artificial intelligence in them. So I think that's something that kind of people should understand that you can get that protected. So it seems like with regard to AI, you either have like the data or you have the AI algorithm, which will be protectable via a patent. So, and it seems like to the extent that you have that AI algorithm, be sure to protect it. And yeah, I think that's something that kind of what I'm seeing here a lot is that. And then I know the USPTO, they just went up on their fees, unfortunately. So that's something to kind of be mindful of. It's not a ton, but no, it's something. So to the extent that you're filing a patent, uh, kind of be sure, I guess, be up to date or understand that those fees have increased as of January, I think, of this year, 2025. So kind of understand that. And then I would probably say those are probably the two biggest things that I can see offhand. Is always kind of a lot of little things that's going on in the background, but maybe those are maybe two of the things that, like I said, with AI just kind of being so kind of big nowadays, and we're talking about costs and how understanding or trying to minimize costs as much as possible. Those are, I think, two important updates that I see going on in the landscape to kind of be mindful of.
Great. So good to know. Yeah, I know AI is very much immersed into the patent space and continues to evolve and change on a daily basis. So that's great to know. I appreciate that. I'm mindful of the time here. I wanted to ask you, for those that want to learn more, do you have any favorite resources or podcasts or places where inventors can get some great information about IP?
Oh yeah, for sure. I think maybe number one, this podcast, your podcast, and it seems like obviously you have skin in the game, not just someone who's kind of teaching this stuff and helping inventors along kind of that process, but also having skin in the game with your product and having gone through that process and selling it. So you know about manufacturing and marketing and protecting IP and all that. So I think this definitely is a good podcast where your guest is getting some quality information. I do have a podcast, Everything Intellectual Property, where I'm also talking to inventors about kind of really their journey. Kind of we talk about how IP is a big part of that journey. So kind of I do have that podcast, Everything Intellectual Property. Actually, just recently came out with an ebook called Got IP, and it's kind of not just on IP. It's kind of from you having an ideal all the way to you monetizing your ideal. It's kind of take you through a lot of different steps in that process, whether it's okay, how do I get an idea? How do I essentially get feedback on that idea? So that's pretty cool that, like I said, just recently came out with. And good thing about it is it's kind of the IP portion of it is kind of based on my 10 plus years of experience dealing with IP. But a lot of those stories that I've interviewed my guests with, like the Shark Tank stories, have been interwoven into the book to kind of give you concrete examples of kind of I guess, the point that I'm trying to illustrate in practice. So that's another good thing that something to be on the lookout for, at least consider, I should say. And I do want to kind of go back. Apologies when you had said some other things to be on the lookout for. I do think just kind of the knockoff situation. I know a lot of people with selling their product on Amazon, with selling it on these e-commerce platforms. The knockoff situation is something that I get constantly when I'm asking people, when I'm interviewing people, of kind of what's one of those things that they're having to deal with, unfortunately. Especially, it seems like once you get to a revenue like a few $1,000,000 of selling your product on Amazon, it seems like it's like clockwork where it's getting knocked off. Unfortunately, a lot of times from kind of Chinese companies, Chinese manufacturers. I know Kevin O'Leary's has been on the record talking about this at length as well. And again, I just think that maybe having IP, having all your intellectual property is going to be important for that. Whether you have trademarks, make sure you have that protected. If you have copyrights, pictures, things of that sort, make sure you have that protected. And excuse me, obviously patents, because you need to look at this as like tools in a toolbox. Okay, I have to cut this piece of paper. I can cut it with a chainsaw, but it may be more important to cut it with some scissors. So if somebody's infringing your name verbatim, as opposed if they're infringing your product, your name, pictures, all that, it may be easier to kind of go after them for copyright infringement or trademark infringement to get the product taken down, as opposed to spending the money to go after them for patent infringement. So I think kind of in that example, you want to make sure you, to the extent that it's something protectable on the trademark side, on the copyright side, in addition to the patent side, to have all those things protected when selling on these e-commerce platforms, because it may be easier ways to get infringing products taken down, easier and less expensive ways to get infringing products taken down outside of having to sue somebody for patent infringement, which a lot of times is going to be more costly in the end. Then also, I would kind of throw in there are also services. Just think of like the personal injury services, personal injury attorneys, where if you get into an accident, they're saying, "Hey, man, no, we're not going to charge you anything. We're going to take your case for free, but you're going to pay us maybe a third or something on the back end once we kind of get you some money for this thing." There are services that also, to the extent that you don't have any money, will kind of help go after these kind of bad actors to kind of get the products taken down, hopefully recoup some money. But again, you may have to pay a little bit of for that service going after the bad actors. So those are things that, like I said, I see a lot just kind of based on me interviewing different business owners, particularly the Shark Tank business owners, that they're doing to kind of combat kind of knockoffs. I know that can be like a game of whack-a-mole trying to get those infringers taken down from like Amazon and a different e-commerce platform.
Absolutely. And thanks for mentioning that. I know there are a lot of good resources out there. For those listening that want to check out your book, is that on Amazon, or how do they find that, and how do they get in touch with you?
Yep, it is on Amazon. So you can definitely go check it out. It's just called Got IP on Amazon. Everything intellectual property, the YouTube channel, the podcast, it is also on there as well. So you can find it on there. And then again, for following me, again, everything intellectual property, the YouTube channel, we're in the process of crossing 3,000 subscribers. So that is growing, which is a cool thing to see. You can catch the podcast, Everything Intellectual Property, Spotify, Apple, anywhere you listen to your podcast, we will be on there. And then just on different social medias, Facebook, David Spears, as well as Instagram. I think it's David Spears _36. You can find me on there, which a lot of times at this point, I'm just kind of posting about intellectual property and kind of different things that I'm seeing on a day-to-day basis with intellectual property. So with those social medias, in addition to the YouTube, it's going to be, like I said, predominantly intellectual property, really for kind of entrepreneurs that I'm trying to kind of push out to kind of start businesses protecting their intellectual property. I'm trying to get on TikTok. So I've kind of started an account. I'm trying to start posting more on there, so it'll be kind of more to come on that. But up until this point in time, I think Instagram, Facebook, and YouTube, as well as the podcast, is going to be the best ways to kind of get in touch with me and just kind of follow me and see what it is that I have going on.
Sounds great. And we'll have a lot of those links down below in the notes as well, so people can just click and check out your book, check out your podcast, connect with you on LinkedIn, and touch base on Instagram and some of the other socials as well. So, David, it's been awesome having you on.
Thank you.
I really appreciate your time and look forward to having you back.
Oh, thank you. I appreciate it, Scott, for like I said, giving me an opportunity to provide some kind of value to your audience. I mean, again, thank you again for coming on my platform and kind of talking to me. And these interviews that kind of I've been doing has really inspired me to not only be a practitioner, but also kind of come out with different products and protect my intellectual property. I talked to you about the Got IP, the ebook, but I'm also kind of coming out with some kids book. That's, yeah, man. You really want. I really want to kind of get to these the kids young, the people young. So I'm coming out with a series of intellectual property books. The first couple are done. My first copyright, my first trade secret is going to be, but I'm also going to have my first patent, my first trademark, and then my first intellectual property that is going to be a 5-part kind of kids book. 3rd to 5th graders that I'm coming out with, hopefully over the summertime. So kind of be on the lookout for that, and I'll be happy to come back and to kind of share updates on that at some point, as well as kind of what I'm also seeing in the IP landscape as changes continue to occur.
Love that. Yeah, the next generation. Let's start them young,
Yep.
get them thinking about IP at an early age. Those little creative minds, that is so incredible what comes out. I think that's amazing. I'd love to have you back on after those you get those out and we can do a follow-up. That sounds awesome.
No, absolutely, Scott. I'm definitely looking forward to it.
Well, thanks so much, David. Really appreciate your time and your expertise, and we will see you in a podcast here in the near future.
Absolutely. Thank you all, and hopefully you guys enjoyed it.
Thanks so much. Thanks for tuning in to the Inventor's Edge podcast. I'm your host, Scott Putnam, and if you enjoyed today's episode, don't forget to like and subscribe, leave a review, and please share it with fellow inventors. Your next breakthrough could be just around the corner. For more tools, tips, and resources, visit us at inventors-edge.com. Until next time, invent with purpose, innovate with passion, and bring your ideas to life.